This is episode 28 of EO Radio Show. Every January brings a slew of new laws that take effect both at the federal and the state level, and it seems that there are always new laws that affect the employer-employee relationship. 2023 is no exception. Our legal topic for today covers the new pay transparency law that applies to California employers. Although our listeners span the globe, even if you aren't in California, these rules may be of interest since the Golden State often leads the nation on the legal front. Join me today for a great conversation with my partner, Chandra Andrade, an employment law partner here at Farella. Welcome to the EO Radio Show, your nonprofit legal resource, brought to you by the Exempt Organizations Group at Farella, Braun & Martel. My name is Cynthia Rowland, and I'm a partner at Farella. I'm a business and tax lawyer with more than 30 years of experience advising clients on nonprofit and charity law. Through this podcast, our lawyers and guests will discuss a range of legal and business issues impacting the nonprofit world because we understand you work hard every day to make your community a better place to live and do business. Many of our programs focus on the basics, and at times we'll do a deep dive into narrow and complicated legal issues. Again, welcome to the EO Radio Show. We're glad you're here. Well, I'm delighted today to be joined by my partner, Chandra Andrade, a member of our private client industry group and the Exempt Organizations Initiative here at the firm. She specializes in counseling employers in workplace disputes and defending them in litigation when necessary. Chandra handles a wide variety of issues, including wage and hour compliance, harassment and discrimination claims, performance management, and workplace policies and training. I know from working with her over the years that she brings a practical, business-oriented approach that seeks the best results in the most efficient manner, and she's particularly effective at working with early-stage businesses and nonprofits that have limited experience with employment issues. Employment law can be an emotionally loaded undertaking where careers, dignity, and livelihood are at issue. Chandra approaches potentially volatile situations in a calm, matter-of-fact, and collaborative manner that emphasizes working together to find solutions. She brings sensitivity to the day-to-day realities of her clients' personal and business priorities, and she takes pride in being a reliable, responsive resource for her clients. She's been a delight to work with over the years, and I'm so excited to have her joining us today. Welcome to the show, Chandra, and thanks for taking time out of your busy schedule to talk about these important topics.
Thanks for having me, Cynthia. It's great to be here.
So today our topic is really the focus on the new requirements for California employers, which took effect in January around pay transparency. But before we do that, let's set the stage a little bit with some general reminders about employment policies and the importance of maintaining an employee handbook for a nonprofit organization. Chandra, can you talk a little bit about why it's a good idea for employers to have a handbook and maybe look at it occasionally, say every January?
Sure. Well, the main reason to have one is that California law requires it, right? There's certain policies in California that employers are required to memorialize in writing and provide to their employees, the primary one being a sexual harassment policy. But in addition to that legal mandate, a handbook serves several really important practical functions as well. For example, the handbook will explain an employer's workplace expectations and the potential consequences for failure to comply with those policies and procedures. And it also helps to demonstrate an employer's compliance with employment laws by laying out that the policies are going to comply with the various features of California law that apply to most employers in the state of any size. Another practical reason to have a handbook is that it can help the employer answer common employee questions that come up very often. For example, a lot of employees are not super sure how they're supposed to go about taking sick leave, for example. And so they can first refer to the handbook as a guidebook for them to understand how they should go about requesting the sick leave. And then the employer likewise knows through the handbook what the appropriate response should look like. Of course, with these different features of the handbook, the employer can help minimize the risk of legal claims by encouraging the resolution of workplace issues through this consistent handbook, guidebook that I've been referring to. And to that point, I think it's especially important for employers to recognize that having a handbook that really lays out procedure and policy around certain common elements that come up in the workplace can really shield the employer against future claims of discriminatory treatment or inequitable treatment, which will kind of dovetail with our discussion on pay equity and transparency today. If you don't have a handbook that helps explain how the employer is supposed to respond to certain employee requests, then that can lead to inequitable treatment or simply different treatment among different types of employees in the workforce. So definitely recommend having that handbook. And as we can talk about as well, it's really good to keep it updated as well.
So what are some of the topics that are covered in a handbook? Is there a laundry list of things that I'd expect to see in a nonprofit's handbook?
Yeah. So as I mentioned, there's a couple of types of policies that are required in California, the anti-harassment policy being one of them. And there's a number of other topics that are commonly included in an employee handbook for more of the practical reasons that I've just addressed. I'll start protecting against claims of discrimination or retaliation. So along with that anti-harassment policy, all employers should have a robust equal employment opportunity and anti-discrimination policy, which often goes with or closely follows the anti-harassment piece. And then relatedly, a disability and religious accommodations policy is really important to help explain how employees are to go about requesting accommodations for disability and religious practice. And then with that as well, there's often going to be an anti-retaliation policy, which simply memorializes the employer's strong policy that anybody who requests certain things from their employer, who engages in any sort of protected activity, is not going to be retaliated against in response to that.
Yeah, and just to jump in here real quick for nonprofits in particular, the annual Form 990 has a specific question that asks if the organization has a whistleblower policy. So just for-profit businesses aren't asked that question on their tax return. Just a note here for nonprofits that policy right there is one that's going to serve the organization well in their publicly available 990. But anyway, I cut you off. So what else do we see in the typical handbook?
That's a great call out there, Cynthia. And I think just to dovetail back on the retaliation piece, the whistleblower aspect of this is commensurate and equally important as, anti-discrimination type of retaliation. So there's different types of retaliation. It can be whistleblowing in connection with work practices and the like, and it can also be something that comes out of an employee complaint of harassment or discrimination. So that's a great call out, and the retaliation policy in a handbook should cover both of those types of retaliation. Other than that, what we've covered, there's other sections around payroll practices and compensation that I would recommend having. These can lay out the different employee classifications in the workforce: exempt, non-exempt, full-time, part-time, that sort of thing. It's important and a legal requirement for an employer to specify in advance when their paydays are going to fall throughout the year. So that's an important section. And then it's similarly important to specify the start and end of the employer's designated work day and work week. So employees know when they're supposed to start their business day, when the work week ends. And that's also important for payroll practices and record keeping. Of course, employers are wise to include sections on standards of conduct and job expectations. So things that would fall into that category would be an attendance policy that explains what happens if employees are missing work, if they're untimely for their workday to start. Relatedly, a meal and rest periods policy is vital for California employers to explain to employees that they're entitled to take meal and rest periods at certain times throughout their shift, applicable to non-exempt employees, not the exempt workforce. But related to the rest periods piece, many employers are wise to have a lactation break policy. So employees coming back from a maternity leave are entitled in California to take breaks for lactation as well. Other kinds of standards related policies that we often see are around dress code and grooming policy, and then codes of ethics and conflicts of interest. I'll tick off a couple of others here. One topic that I commonly see in a handbook is around performance management. Many employers think, well, we need to have in the handbook this section that explains, what a progressive discipline system will look like for their employees who violate policies or procedures in some way. And I should caution employers that while it's great to have such a policy in their handbook, it's only as strong as the enforcement of that policy is going to be. So if you're going to actually follow the progressive discipline that's laid out in a handbook, for example, starting with a verbal coaching and then moving up to a first written warning and then a final written warning. As long as you're actually going to follow that, it's good to put that in the handbook. But if you're not going to follow that, then again, going back to what I said earlier, if you're not following what's specified in the handbook for everybody, then it can lead to claims of unequal treatment. So only include that performance management section if you're going to follow it.
Yeah. So it's actually worse if you have something in there and you're not doing what it says.
Absolutely. Yeah, exactly. Yeah. Other really vital policies in California are around time away from work and leaves of absence. So not only for paid sick leave and the FMLA/California Family Rights Act and pregnancy disability leave policies, which are mandated in California for most employers, there's a variety of other less well-known types of leave in the state that employers should go ahead and include in the handbook. That can be jury duty, military service leave, witness and victims of crime leave, bone marrow, organ, and blood donation leave is an actual required leave of absence in the state. And then we'll talk a little bit more about this later, but there should also be a bereavement leave policy in the handbook as well.
So that covers a lot of ground. I guess there's probably some other lesser, well, actually, they're probably even more important, health and safety policies. Those are kind of far afield from pay transparency, but what are some of the health and safety things that you typically see?
Health and safety policies are good to include in a handbook for employers to use in the event of different health and safety events. We know all too well about the COVID-19 pandemic and what that required of employers in terms of face coverings, letting employees take time off for illness. So we definitely see many employers now having a COVID prevention or face covering policy. Those were required during the course of the pandemic and are not exactly required anymore, but many employers prefer to still include policies around face coverings and other aspects of the workforce that may have changed permanently as a result of the pandemic. And then relatedly for health and safety purposes, lots of employers will have a drug testing policy in the health and safety section addressing to what extent employees may be subject to drug testing. Usually we'll find that in workforces that have more health and safety tinge to it. So drivers, delivery drivers, and workers of that nature who need to be drug tested. That's a policy that would certainly be in the handbook. And then for many other employers, simply a heat illness prevention policy can be helpful as well. You know, what to do in the event of extreme heat and letting employees get a breather, those types of policies. And then lastly, a no smoking policy is pretty common in handbooks as well.
Yeah. So I can see now why, with this all outlined, why the handbooks seem to be so long. It needs to cover a lot of ground. So shifting gears now, so that lays the background for handbooks and what's told to the employee about the employer's policies. This new California pay transparency law, maybe that's not something that specifically affects the drafting of a handbook, but it's certainly going to affect your relationship with your potential or I guess even your existing employees. So why don't we start with a kind of an overview of what this law does, and then we can tie it back to how or whether it even fits back in the handbook or how you go about implementing it as an employer.
Sure. So the California pay transparency law came to us through Senate Bill 1162, which was signed into law last fall and took effect, at least most of the provisions took effect this month. It creates substantial changes to the employment landscape in California, with the purpose of the law being to help pinpoint patterns of wage discrimination in the workforce. So the law seeks to address pay equity from really all fronts, including prohibiting consideration of salary history in pay decisions, equipping applicants and employees with equal information from which to negotiate their starting pay, and then requiring the reporting of compensation to the state.
And just a note to our listeners, we'll have links in the show notes to the law itself. For those of you who want to actually go back and read it, I'll put a link to SB 1162. Is that what it is? California Senate Bill 1162. And we'll have some other links in there about for some resources. But anyway, the law just came into effect January 1. Is that right? January 1, 2023?
That's right. So the new pay transparency requirements took effect January 1st. And then there's a second piece of the law that around paid data reports that have to be submitted to the state. And that aspect of the law takes effect in May of 2023.
Okay, so a few months to get your data together. So what changes does the law make about disclosing pay ranges? Let's just dive right in.
Sure. So some of the listeners may be familiar with other recent changes in California law around pay transparency. So existing law before SB 1162 had prohibited employers from asking job applicants for what's called salary history information. In other words, if you're interviewing an employee, you can't ask them, well, what are you making at your current job? However, employers could ask about an applicant's salary expectation for a position. So what are your forward-looking expectations for what you will earn in this job that you're applying for? And then after an applicant has completed an initial interview for a position, an employer had to provide the position's pay scale upon a reasonable request. So what SB 1162 does is it expands the pay scale disclosure requirements to cover current employees who request the pay scale for the position in which they are currently employed. So obviously a big deal for employers to now be having to provide compensation information to their current employees who simply need to ask for it, and then they're entitled to receive it. It also broadens the requirement to any external applicant seeking employment with the employer who makes such a request. So rather than requiring that they complete an initial interview first, like existing law required, now any external applicant can request the pay scale from the prospective employer. There's some new record-keeping requirements that apply to all employers regardless of size. And so employers must maintain the job title and salary history for all employees during their employment and for 3 years thereafter. So a reminder to employers to be keeping solid records of their job title and salary history for all their employees for that pretty lengthy period of time. And then as an additional requirement that really supplements existing law, employers with at least 15 employees, so that's not counting bona fide independent contractors, must now disclose pay ranges in their actual job postings. So employers now have to post pay scales on their job postings, even if the employer engages a third party to promote or publish the job posting, like Monster or Indeed. So that's a real change, since now any job posting that an employer is going to put out into the public for any position, it has to actually include the dollar amount or the pay scale that's going to be paid for that position. I should note in terms of that pay scale posting, it has to be the dollar range for the amount that's going to be paid for the job has to be physically visible in the posting itself. So you can't put a hyperlink in the job posting that takes somebody to another page. It's got to be actually visible in the posting itself. And then, I think what's important for employers who have this increasingly remote workforce to keep in mind, the recently released FAQs that the state has published on this new law clarifies that the pay transparency requirements apply even if the position only might be filled in California. And that specifically may apply to both in-person and remote positions. So if you're an employer even outside of the state and you're posting a job that maybe results in a hire in California, even for a remote position, then you've got to include that pay scale.
Wow, that's pretty huge, actually, for in this day and age of flexible, sometimes remote, sometimes in person, and people living anywhere. That's a huge issue for non-California employers. So can you talk a little bit more about what the pay scale is supposed to look like? Is it like the hourly pay, or does it depend on if it's a salary not based on hours?
Yeah, so the law itself defines pay scale as the salary or hourly wage range that the employer reasonably expects to pay for the position. So that reasonably expects gives a little bit of wiggle room as to what the pay scale needs to show. For fixed pay positions, the employer should post the fixed wage or salary. So it's a little bit easier if there's just an hourly position that the employer's hiring for and they know what that pay is going to look like. You just put that pay. If there's a range of some sort, you can include a range. If applicable, though, the pay scale must also include piece rate and or commission wages. So that makes it a little bit more complicated for a sales employee, for example. There should be some aspect of commission wages factored into the pay scale. I should note that the employer does not need to post additional compensation such as bonuses, tips, or other benefits. That doesn't need to be included in the pay scale.
So circling back, employer lists the pay scale. All of their current employees, by definition, are going to be able to see it because if they go look at the job posting, they'll see it. And I'm presuming that pay scale that's in the job posting needs to match the reality of what the employees are in that position are actually compensated at.
Exactly.
Right. So this is a pretty big deal for employees to understand where they fit within the pay structure.
Absolutely. And I think, the purpose behind this law, like we talked about, was to foster pay transparency, to enable existing employees as well as applicants to have visibility to what others are receiving in terms of pay, so that if there is a disparity between new hires and old hires, that disparity can be rectified. If there's certainly a disparity between male and female employees, that disparity should immediately be rectified as well. So absolutely, employers need to be thinking about this law as arming their existing workforce with way more information about pay that's being provided to other employees.
Yeah, that used to be enforced in much more difficult mechanisms. So aside from penalties, as in an unhappy employees or an unhappy workforce, are there other penalties for failing to disclose the pay ranges? Is there an enforcement mechanism outside of your own employees enforcing fairness?
Yeah, there are. There's some pretty significant penalties attached to the law. So civil penalties can actually soar up to $10,000 per violation if an organization fails to comply with pay disclosure requirements.
Wow, those are pretty hefty penalties. You mentioned SB 1162 also made changes to the data reporting requirements. Talk a little bit about data reporting. I guess this starts in May of this year, so we better start getting our act together.
That's right. And employers that have 100 or more employees should already be familiar with the concept of paid data reporting because federal law has required it through EEO-1 reports for quite some time. So similar to those federal paid data reporting requirements, existing California law had already required employers with 100 or more employees. So that's with at least one employee in California. Those 100 don't need to all be in California.
Okay.
To annually report data on each of 10 specified job categories to the California Department of Fair Employment and Housing, which now has a new name, the California Civil Rights Department. And previously, only private employers with that 100 or more employee threshold were required to submit paid data reports to the department in California if they were already required to do so for the federal government. So filing those annual EEO-1 reports that I mentioned. Employers were also permitted to submit their annual EEO-1 report to satisfy the state's paid data reporting obligation. So starting in May of 2023, that's not going to be so easy anymore for the California employers. All private employers in California with 100 or more employees will be required to submit paid data reports without regard to the federal EEO-1 reporting status, and they're no longer going to be permitted to submit that EEO-1 report in lieu of the California paid data report.
So for most of our nonprofits have a lot less than 100 employees. So they're not going to need to worry about the data reporting either at the federal or the state level.
That's correct.
But then again, so just to set minds at ease for the small nonprofits. But there are many large nonprofits that do have 100 employees, and they'll fall into this. Okay, so with that clarification, sorry, I interrupted you again. Anything else to say about what goes in this data report?
Yeah, so not to get into too much of the weeds here, but for each job category, employers are now going to have to include the median and mean hourly rate. So that's a pretty material change from existing law, which had only required numerical counts of employees by race, ethnicity, and sex within each job category's pay band. The employers in California now have to actually specify what the median and mean hourly rate is to make that dollar figure much more apparent and transparent to the state and then others who may seek out this information. I should also point out, to your point, Cynthia, there's many nonprofits that are not going to meet that 100 employee threshold. As I mentioned, though, the counting of the employees applies to anybody outside of California as well. As long as the employer has a single employee in California, then the employer has to count the rest of its workforce and see if it meets that 100 employee level. And temporary employees people outside of just full-time employees are also counted there. So, that number can certainly add up if there's a nonprofit that has maybe a small presence in California, but then other offices in other states. Another significant departure from existing requirements is that in California, private employers with over 100 employees who are hired through labor contractors in the prior year will also be required to submit a separate paid data report covering those contract workers. So again, probably not super applicable to the nonprofit space. Many nonprofits don't use labor contractors to finish out their staffing, but just something to keep in mind.
So backing up a little bit, maybe you said this and I just missed it, but this is total number of employees, not just full-time equivalents.
Correct.
So if you have a lot of part-time employees, they're going to count. It's the number of actual employees, temporary, permanent, part-time, full-time, if they're an employee. And I guess we should probably plan another episode for what the distinction is between employee and independent contractor. That's another huge question, but we don't need to go there today.
Well, that's a good point, Cynthia, because, the 100 employee count can exclude independent contractors, but only if they're properly classified as such, right? And so you do have to keep an eye on that, and the correct classification is immensely important, as you know from your work with me over the years. It's really vital to get that classification right.
So let's plan another episode on that topic. But anyway, staying on message here. Do you have any tips for nonprofits that are covered by, all the nonprofits are covered by the pay transparency and then the data reporting for the larger ones. Any tips on how to make this as painless as possible?
I'd say the first one is probably just the most obvious from the pretty black and white requirements that we've talked about around pay transparency. And that's that employers who meet that 15 or more employee threshold now have to be updating all their job postings to include that pay scale information. So to that end, employers may want to develop pay bands for each role in advance of starting to make these posts. Again, the posts now have to have the pay scale because we're into January and the law has already taken effect. But for those listening who haven't made these changes, I've seen a lot of employers develop these bands for each role, which itself can help the employer suss out any potential disparities between current employees and what they're making and what they're now going to be posting and offering to prospective employees. It's also a good idea to develop a process for consistently pushing out wage information to those who are responsible for posting the job opportunities. So that's not always happening. And this law really inspires employers to start doing that, right? The people who are going to be out there recruiting, who are going to be making the job posts, they just need to be kept apprised of any changes to wage rate and information of that nature. And it's important for employers to develop and maintain a process for preserving the job postings, because as I mentioned, there's that record keeping requirement that applies to employers of any size of keeping this job posting and wage information in their records for at least 3 years. It's maybe a little obvious, but often overlooked, right, is training. It's really important to train any relevant employees on these new laws and the processes around the new laws requirements. For example, managers who are going to be giving interviews should know the do's and don'ts around salary conversations. And then for probably mostly larger employers, this might be more applicable, but it might be appropriate to do an internal audit to ensure that there aren't any discrepancies or inequities in pay. So that audit would entail usually working with a consultant or outside legal counsel to do a really deep dive into all the pay information within the entire workforce, matching it up to gender, to race, to different protected categories, and then just seeing if there's any sort of discrepancies there and certainly rectifying any that come out of the audit. And the audits are important because they can avoid causing situations where the pay for current positions does not reconcile with the new positions that are going to be posted. To your point earlier, Cynthia, this law is going to arm existing employees with this information about what prospective employees are being offered for pay scale. And so it's just really goes back to the purpose behind the law of employers looking at their pay, looking at trends across different classifications of employees, and doing a real check on the health of their pay and the equity of pay across their organization.
So, Chandra, are there any good resources that you can think of off the top of your head for listeners to get further information about this? I know we'll put in the show notes our recent firm publications and notes on this topic and other employment practices. Anything else that comes to mind for further information?
The California Civil Rights Department, formerly known as the California Department of Fair Employment and Housing, it has posted some FAQs on California pay transparency as well as the reporting aspects of this. So that's probably a good first stop for employers to reference, especially those larger employers that are going to be worrying about the pay disclosure. There's some trickiness around that. And the California Civil Rights Department has a pretty user-friendly list of frequently asked questions and responses that can be a nice resource for employers. And then similarly around the pay transparency and what the job postings need to look like, et cetera.
Oh, that's great. Okay, so we'll put that in the show notes as well. So I think we'll wrap up for now. Thank you so much, Chandra. I really appreciate you coming on the show today and talking about all these important topics. And I hope we haven't scared the nonprofit sector to death with this. But thanks very much for coming on the show.
Thanks for having me, Cynthia.
So that's all for this episode. Be sure to check out the show notes for links to more resources on the new law and employment law resources in general. I'm Cynthia Rowland, and you've been listening to EO Radio Show, your nonprofit legal resource, brought to you by the Exempt Organizations Group at Farella, Braun & Martel. If you have suggestions for topics you would like for us to discuss, please email us at eoradioshow@fbm.com. That's eoradioshow@fbm.com. Thank you for joining us. Until next time, make a difference.